Hi guys, it's Kathy. I hope you're doing well. We made it to Wednesday. Remember, no stream tonight. I gotta work a double. But we do have a stream today. We're gonna go to Judge Christopher Funk. We haven't seen Christopher Funk in a while. Now yesterday we did for they both have the correct attitude to be a judge. Let's just put it that way.
Somewhat, I think, difficult case for the court's relationship to sentencing. I state that because of most recent history, mental health. He's had a fair amount of instability for a period of time. I think a lot of that is because of the mental health issues, and then ultimately as a byproduct of the addiction issues that he's been struggling with. This is an attempt crime. I think that the vast majority of it just actually occurred just a block to the east of here, over by Selper Chocolate Cafe, and it was captured on the security surveillance systems by the city. And it shows a person who I think was clearly, this happened earlier in the morning, was clearly in a position of distress just based upon the pacing that you could observe. I think the person that he was interacting with was somebody that had volunteered themselves in the past relationship to folks that are homeless, mental health issues. And there's a confrontation that takes place, and I walked through the video with my client. Clearly, he's the one that re-engages with this individual in the street, and there was never any injury, really no contact between my client and the victim in this case. He actually had a small blade on him that he dropped during this in the middle of the street. And I think a lot of the catalyst of this was his own words, where he hadn't slept for a while, some agitation. And I think it's based upon what I'm trying to articulate to the court. This wasn't any ill will or bad blood towards the person. And I think it's probably a fairly unlikely event to reoccur because there was a lot of things that lined up at that moment that happened. He's been very willing to engage with me throughout this process. He's been in custody for now over 300 days.
Can anybody remember this lawyer's name? I can't even get close. I can't. Maybe they'll say his name.
On that point, around 3:15.
Right. And
State, any thoughts on?
If you do the way probation calculates it, it's 3:14. Obviously, in custody of that is still up to 3:15.
Thank you. I'm sorry, sir. Continue.
so, the Central County Community Corrections came back, statutorily ineligible based on the nature of the offense. And see, obviously, there's a financial component, housing component that's required in order to participate in that program. I think that when the court looks at his history, he doesn't have what I would call, I think, more severe history. In the prior two times that he was placed on probation, he did complete probation. I think there was one petition filed that was dismissed, but it was a financial issue, not a substantive violation. I think that in speaking with my client, he does need the mental health addiction side component. And I think if you look at the PSI, he has engaged in that behavior in the past, or in that interventions in the past. And my hope is that the court, based upon the nature of time that he served, based upon the catalyst of this offense, and I think the unlikely of this event reoccurring, that the court provide him with an opportunity for probation to see if he can't get a little bit more of a strong trajectory going forward with some treatment. And, if he's successful, I think that everybody wins. And if he's not, the court would have the opportunity to bring back in and readdress whatever was not being addressed responsibly under those circumstances. And I think that, he's just one of these clients that are challenging to address, because you read what's on paper and then you go and meet the person, and the person is a completely different presentation than what you see on paper. And most certainly when I look at the video, applying a handful of times, it's not the same person that's sitting here in court today. And I think that is why it makes it challenging. If it was, then perhaps the court's outcome would be much different, because it's just a much different person, much reflective, much calmer, much more organized person who's sitting here, and that I've experienced than obviously the person that showed up that day. So based upon that, we would ask the court to consider the amount of time that he's been in custody to date, a sufficient punishment aspect of this, and allow him to transfer to probation, and hopefully engage in some significant rehabilitation.
Thank you. State your thoughts.
Your Honor, he's got the aggravator of his criminal history, the mitigator of accepting responsibility. He's got 7 priors, 5 misdemeanors, 2 felonies. Frankly, I agree with a lot of what Mr. Britton has already said. I think, I don't know that Mr. Martinez is the most concerning person that this court has come across today. You know, there's some concern based on his history, and obviously this is an attempted battery with a deadly weapon. I agree that it appears that Mr. Martinez was not exactly himself that day. Whether that makes it better or worse, I don't frankly know, but I think that it is important to keep in mind. I'm concerned about Mr. Martinez's likelihood of success on probation, given and where he's at in life right now. However, I think that is the most appropriate response at this point. I hope that Mr. Martinez is able to engage in services. I think that is what he needs at this point, is most appropriate for him and for the community at large. So that is a short and long way of saying I agree with Mr. Britton's assessment. I think
That was not short and long, sir. It was one of those two. You're right. It was not both of those two. You both talked a long time.
time served as far as initial executed sentence is appropriate, followed by a period of probation. My recommendation would be 2 years reporting probation.
Okay. Mr. Martinez, you've heard what your lawyer in the stadium said. Do you have any thoughts you'd like to share with me today, sir?
I'd just like to apologize to the person that I engaged with. That's my
State no contact order.
That is terminally, Your Honor.
Has one been submitted previously?
I don't,
I'll show that we have one.
I believe it would have been submitted through.
Beat up the pastor. It looks like this guy got into a fight with someone who was reaching out to the homeless, who regularly does that and tries to help them.
Through the system, it would just need to be approved. If not, I'm not sure that's good.
Okay. We'll follow up with that. Well, so, Mr. Martinez, I'm going to accept your guilty plea. One thing I wanted to ask you before I go ahead and make your sentence is that nobody made you any promises to get you to do this plea based on that immigration status, right?
Right.
Okay. I want to make sure that having it explained to you didn't equate to a promise of what would or would not happen. So just that's their legal opinions that may or may not bear out, but you understand that we're not making any promises about what will or won't happen with regard to that part of your life, correct, sir?
Mhm.
Okay. I want to make sure that was pretty clear. All right, then, look, you spent 315 days of Class B, that you'll earn Class B credit for, incarcerated. That's a pretty substantial penalty for anybody. And I think that, particularly for you, where you, as your lawyer said, you didn't actually hurt anybody, and maybe this was a perfect storm, and everything came together and conspired and put you in a really bad spot. Some of those things you could control, some of them you maybe couldn't. But you're going to need to, you're aware that can happen to you. So you need to take measures to ensure that it doesn't happen again, because it endangers you and it endangers other people, correct?
Right.
Okay. And I know that life hasn't always been kind and easy to and it's harder for you than it's maybe for some other people to control your destiny in some aspects. But that's when you have to make those hierarchical decisions about, okay, this is something I cannot allow to happen. You know, you cannot be up for 5 days without sleep. That can't be something that happens. And I understand it can be hard if you're outdoors, you know, and you don't have a lot of great options, but your brain, your body cannot function without it. And there are no substance, caffeine, drugs, none of that stuff can be a substitute for sleep. Your brain needs that. Okay. You may be able to keep your body running, but your brain needs that rest. And I know that you don't feel safe. You don't feel like you're in a place where you can rest and relax. You gotta find a way to seek that out. Okay. I agree with the parties that the time served is sufficient. So you'll be released, but as soon as you get out, you'll go up to probation. Your sentence is going to be 4 years total. The time executed time is the time you got served, 15 days plus good time credit. The balance of that time on probation. So it'll equate to probably a little more than 2 years, but that's going to be your probation time. And during that time, you'll do mental health and substance abuse evaluations and programming pursuits of probations, requests, or orders actually. And if they order you to do something, you'll have to follow through with it, okay?
Yes.
Okay.
Oh my god, I have a great idea for a stream, guys. The judge just gave me a great idea. It's his idea, really. I'm just rewording it a little bit. We should hire one of those evaluators for our chat. We all have to take a mental health evaluation, and then we'll read the results in chat for everybody here. I wonder what they'll say.
On grant 315 days. Class B.
Guys, it really would be
I don't know
freaking
exactly how many days
hilarious.
that leaves you on
Shut up, Judge. It would be very hilarious. Oh my god. The more I think about it, and put a mental health. Try to think about look at the people in chat. Look at one person in chat and think about what their mental health eval would say. I would be in trouble. It would be long. We'd be here for a day.
probation, but it's a pretty substantial period. It's not meant to punish you, it's meant to try to help you. But if we have further incidences, we may have to come back and talk about more of a punishment type of situation. With regard to court costs and public defender fees, when you find that you are indigent, I'd like you to try and make probation fees during the term of your probation. It's $150 up front, $15 a month. If you cannot make those fees, then we'll work on that, but that will be a sole basis for a revocation or anything like that. Okay. If you do have money, you're able to work, they can be expected to help pay for those things, okay? State, the NCO will continue as a term of
A couple of you would be really, really, really short. Letters WTF in shaky handwriting.
your sentence. That means you know this gentleman, you know who you're talking about. You cannot have any contact with him, okay? Go places where you know he's gonna be, things like that, okay? Anything. Okay, she's got that protective order right here, so she'll give you that as well as your rules of probation. Go with your attorney. If you understand them, go ahead and sign off on them. You'll be bound by them, and then you'll go see probation as soon as you get out. You know where probation's at, sir?
Yes.
Okay, go see them on the 4th floor of the county city building as soon as you get out.
Okay.
Steve, am I missing anything else?
I don't believe so, Your Honor.
No.
Good luck, Mr. Martinez.
And last night, Carter Scotchfield.
Yesterday after the stream, right after the stream, I drove my daughter into work. But I didn't have to work for another three and a half hours. So I grab my laptop and I go to McDonald's. And I'm sitting there trying to work. And like, oh man, I was so tired that I really couldn't get any work done. So I got in my car and I drove to this park. And I parked at the park and I fell asleep. And it wasn't a nice light nap. I was deeply asleep. It was amazing. It was the deepest sleep I think I've had in a long time. I don't know how I got up. I don't know how I woke up and made it to work on time, but I did. It wasn't that hot out yesterday. It was a little hot, but not that hot. So it was lovely. Oh, I kept thinking about that little nap all day long and how wonderful it was. That's legal, right? As long as you're not sleeping there overnight and you don't set up at your own tent. I don't think they're allowed to, Sherry. Maybe if someone did a welfare check, right, then the cops could bother me, but I think that you're allowed to do whatever you want to do in the park during the day, as long as it's not illegal. And sleeping is not illegal, right? I don't think I did anything illegal. I didn't get busted. I did not pee. The parks actually have bathrooms. So I actually could have if I wanted to. But I was too busy, Jerry. I was sleeping. It was lovely. It was so good. I think it was because I wasn't at home. There were no animals bothering me, no kids to worry about, nothing to worry about. And it was just me at the park. I think my body was just like, whew.
Clause number 2603 F27, Carter Scotchfield. Stuck in Marshall County.
Well, so this is a case that involves St. Joe and Marshall County. We have a plea agreement up here that theoretically dispose of the Marshall County case. I would ask the court to reset this. I believe the intent down in Marshall County was to continue out. Here you see that set down there, so you can get brought back up here. The plea agreement up here contemplates dismissing the Marshall County case. So it's been a good discussion with the St. Joseph County Prosecuting Attorney's Office, the Marshall County Prosecuting Attorney's Office, his counsel down there, and I think without going into too much detail, the court looks at the type of offense in Marshall County coupled with the significance of the offense up here, that the intent is to deal with it all under one umbrella and try to piecemeal together potentially consecutive concurrent sentences. So what I would ask is this case, we can get him back up here get that done. I think that my hope is that at that point in time, we will go sentencing and all the cases will solve at that point in time.
How far are you looking to go accomplish that, sir?
Well, I thought I had notes, his next hearing date, I didn't.
8:10, this is jury trial.
So my understanding is that will be continued, so I would just ask for 2 to 3 weeks. So that way we have enough time to get a transportation order, so maybe the week of the 20th again. We do 7/22.
All right, so on the pretrial conference, is that a motion to continue on your behalf, counsel?
It would be a motion, I guess, to be very clear on that, motion to continue the jury trial on 8/10. And then reset this for a status conference on July 22nd, acknowledging the delay of CR4. And requesting them to transport that out from Marshall County.
That's a super clean record. Thank you. Then that motion would state concur to the it's appropriate.
Yes, Your Honor, no objection.
Okay, no objection. Then, without objection from the state defense motion to continue, the trial is granted. That trial date in August is vacated. We'll set this matter for status on 7/22 and will enter a transportation order. You have Mr. Stedfield brought back from Marshall County to St. Joseph County to see if we can address these issues. Thank you, counsel.
Thank you, Judge.
You want to go forward? And you're in.
Good morning, Judge.
Good morning, Mr. Techley.
Judge, with your permission, I had an add-on this morning.
Who's your add-on, sir?
John Artusi, who was in custody.
Okay. Has Mr. Artusi been brought down?
No, he hasn't. I just wanted to make a record and ask you a question about this. And I'll be happy to wait if you would like also to see him on camera. I'm refreshing, of course, recollection that when we were here in April for status, he was in custody in Elkhart. I've been in contact with him. He always did a good job keeping in contact with me. He was arrested March 18th. I'm showing you the hearing order leading up to June 22nd. He did enter a plea for time served. I thought there was a hold on him because of your warrant, but he was released from the county jail in Elkhart, immediately contacted me, and that was the week before you were going on vacation. I told him I'd put a motion on file and try to get a 8 o'clock hearing date for him to appear with me, but I didn't get that done before you went on vacation. He was taken into custody July 1st, a couple days before you went on vacation. He called me July 2nd and explained that you were not going to have court on the 3rd. And so I told him that I would either file something or come in and see you. He did post a $3,000 bond when this case started. You did release $1,500 as fees. It's a private case. And I would tell the court he's always kept in contact with me. When I told you in April, the circumstances of him being arrested in the Elkhart, then you'd say we will revisit whether you will consider releasing him on bond previously posted under those circumstances. So I wanted to come in and bring that to your attention this morning to see if you might consider my oral motion to release on bond previously posted instead of status hearing. Could even be this week. I'm pretty flexible.
State?
Your Honor, I think to keep it the cleanest, especially since he's had all these irons in the fire, if the court is willing to reset Mr. Artusi, if Mr. Keckley is available to come back as soon as tomorrow, if he's still in custody, we could get
Terry, thank you so much. 2 years on multiple.
him dates and then we could discuss ORing him. I don't know how much the state would be opposed. I can say in my case, which is a possession of methamphetamine, I wouldn't be opposed. I don't want to speak on behalf of Ms. Harmon, given her case is slightly more severe than mine. I wouldn't object to him being OR'd, but he's already in custody. I'd rather we just get him in, get him dates, and then be able to go from there just to make sure we keep it clean.
Oh, I'm sorry, was there a dual arrest when he was taken into
He
custody?
has the two cases. He has one with me and one with Ms. Harmon.
Oh, that's right.
If there's something new.
Yeah, I have both cases, that's right. I'm sorry, I have both cases. He was just taken into custody with that incident, and there's no new charges pending.
Yeah.
And the bond relates to those.
Well, Mr. Keckley, because I'm in receipt of your documents for Mr. Jones sentencing for tomorrow.
Yes.
I know that you're coming back tomorrow.
I'm coming back
So
tomorrow.
let's set Mr. Archibald's cases. Those would be 71 DO 12512 F6 1277 and 2601 F6 47. Let's set them for tomorrow. Have Mr. Archibald brought over. I'll return these documents to you because I don't have a file to keep them in, but we'll take up his case tomorrow. Okay, state can check with the DPA.
Thank
We'll
you.
have everything kind of encapsulated and all together. Okay, sir?
I bet. Thank you very much.
Thank you.
Let me bring this to your attention.
Morning, Your Honor.
Good morning, Mr. Kozlowski.
I've got several cases to take up. Could we begin with, let's see. Could we begin with, let's see, Chas? Could we begin with Chaswell, please? Chaswell.
Mr. Whitmer?
Whitmer, please.
Here we go. Cause number is 2606 F6 610. Mr. Whitmer. Good morning, sir.
Good morning.
Mr. Whitmer, we are set for an initial hearing today. Your thoughts, Mr. Kozlowski?
Your Honor, we want to get this on the trial calendar. I would let the court know my client is set to meet with Gary Greiner for potentially hiring him as private counsel on Saturday, I believe. Yeah, Friday or Saturday. And so there may be a chance that we have substitution of counsel here. But after talking with my client, he's comfortable putting it on. If Mr. Greiner needs a new date, then you can request one. But going just to get this thing moving, I would just ask to be have a trial during the course of business.
Under those circumstances, I think maybe not my absolute quickest, but maybe just further out, perhaps 9/17.
That works, Your Honor. And I told him that it was likely to be in September.
Okay, then we'll set your trial for 9/17, sir. If you don't appear for that trial, it could be held in your absence. Understood?
Understood.
Okay, and then we'll set a record date mid-August to see where we're going with this. A record date is your last chance to enter a plea agreement, also a last chance to file any motions regarding your trial. So we'll set that for that's mid-August. We can add.
This judge will not take a plea day trial like Reagan's did. Reagan's did save time, though, I guess.
Perhaps August 20th would be a Thursday. I don't know of any impediments on Mr. Greiner's standing schedule.
And that works for me, Your Honor.
And so it does work for you in case there's no substitution?
Yeah, that works for me, Your Honor.
So then we'll set it for 8/20 for record. As I said, that's a deadline for entering a plea or filing any motions. If you're going to have a lawyer get involved, another lawyer, perhaps Mr. Greiner even, the sooner the better, because he's going to need some time to tool up on this and get ready for it, okay?
Okay.
So just know that your next scheduled court date is 8/20, and if you, another lawyer enters with new dates, they can file something, we can get you in the court sooner, okay?
Right.
Anything further?
That should be it, Your
All
Honor.
right, thank you, sir. We'll see you 8/20, if not before, Mr. Whitmer.
It's
Thank you. Appreciate it.
a pleasure meeting you, man. Next, Your Honor, can I take up Joseph McDonald? He's in custody.
Sure.
So he may, oh, there, it's okay. Hold on.
Joseph Terry McDonald, cause number 2605 F5 127. It's a new one. I'm going to set for trial now. It's 2602 F6 129. Your thoughts, Mr. Kozlowski?
Thank you, Your Honor. The court set this out to give us a little bit of chance to talk about something my client wanted to make a counter offer. I made that to the state. Unfortunately, what my client wants, I don't think we're gonna be able to make it happen. The state was pretty flexible with me on trying to figure out a solution to this, but I have not been able to crack this particular nut to get what Mr. McDonald's looking for. So we're gonna confirm this trial, though. If something changes, I'll let the court know, but we are confirming at this point.
Or Charlie again, sir? So, what?
8/17.
8/17, okay.
If I may.
Then go ahead, state.
I apologize, Your Honor. So the state has some witnesses who are unavailable. I've been holding off formally filing a motion to continue because we've been in negotiations. At this point, I do need to make a oral motion to continue due to some unavailable witnesses.
Okay.
And Your Honor, if the state would be willing to keep plea negotiations open pending this, the defense would be willing to take CR4 time.
Okay. State, is that an agreement you're willing to make?
That is fine, by me, Your Honor.
Okay. So where we're at, sir, is the state has unavailable witnesses on the 8/17, and normally today would be a deadline for entering into a plea agreement. Your attorney has been working on that, but we're not there yet. So I think a short reset of the trial would be appropriate. Does that seem reasonable to you? To give you a little more time to A, explore the possibility of a plea, but B, make sure that that's the route we need to go. Does that seem reasonable to you, sir?
Me too.
Yes, sir.
Oh, I didn't know. I thought you were talking about
Sorry.
yeah, and another thing, I'm just trying to see, Judge. I've been here since May the 15th. My bond, I never asked for a bond reduction. I never felt it. Let me just keep going back and forth to court and see what's going on with the case.
Yeah.
And my bond is set at 10,000. And I'm just saying if it can go down, I mean, I don't know. I mean, cause like they said, a closed mouth don't get paid if you don't act.
Yeah.
Right, that's true. That's a good point.
Yeah, so I said, you know, if our bonds go down, I know I'm already out on a $2,000 bond, you know, and on the first case that happened back in February, for possession of crack cocaine and a Class A misdemeanor battery. So,
Your
Okay,
Honor,
hang on, let's hear your lawyer's thoughts.
may I ask my client a question? What could you afford as far as a bond? You obviously can't afford the 10 grand. Is there an amount that you can't afford, Mr. McDonald?
before, like, anywhere from $500 to $1,000. At the most, I mean, like you know, I'm not going anywhere. I handle these cases. And I never, even if I could,
Wait, hold on. Let's stop. Let's cut. Yeah, let's cut it off there real quick, Mr. McDonald. So you got a place to stay, right?
yes, I got a place to stay with my uncle at 608 Solomon Drive, Parkman Creek.
And Your Honor, just in terms of my argument here, my client is good with communication overall, and I have had no problems with that here. I do recognize that he picked up the second case. I would just say proffer that 10,000 might be a little on the high end. I do recognize that my client has history and that we are talking about firearm charges. However, my client is not, I don't think accused of riding around, firing shots at people or anything like that. But, this is a situation where, it is dicey when we're talking about firearms here, but, we are asking that he be released on lower bond. I would ask either the court set it between that $500 and $1,000 range that my client can actually make. Thank you.
Thank you. State thoughts?
I leave it to the court's discretion, Your Honor.
When I consider the fact that he's apparently under supervision, on a PTR pending on a CM matter, that he's out on bond with another matter, that there's a fire involved here. That
What do you mean you leave it to the court's discretion? I'm sorry, but you're getting paid as a prosecutor. If the prosecutor doesn't care, Judge, why do you?
his criminal history is pretty extreme, suggesting potential danger to the community. The bond's gonna remain the same.
Understood.
No harm in asking, but I'm not gonna change it, sir. So my question then becomes, are we setting a new trial date today
I think it would be best to get it
in
back on.
both cases, or just primarily set the one, have it set for status?
Set for trial.
I think, hold on, I think we have another trial date for the one that's farther out, don't we?
Oh, okay.
Session.
Oh.
Oh, sorry, for the F6.
Okay, yeah. That's what we're here on.
Right.
For the record for.
Oh.
Okay.
You have 5 minutes to determine this.
8/17. So that one we already got a trial date on.
Right. Oh my God, most people, well.
Hold on. Mr. McDonald, he ruled on it. Let's not argue right now, okay? Yeah, I understand what you're saying. I do. But let's not argue right now, okay? Thank you.
Sure, on that. We're on that. Yeah, 8/17 is the setting on the F5 case.
Yep.
Okay.
I think it just said you put it as a free trial. Yeah.
7/23 is the setting on the, okay, I misunderstood earlier. All right, so which date did the state have issues with?
It was the 7/23 date.
Okay. All right. Well, then, since we already have 8/17 as a date, we can reset the other trial to that same date.
Yeah, I have no problem with that at all. Yeah, defense has no objection.
State,
That should be fine, Your Honor.
okay. Then, Mr. McDonald, what we'll do on the 2602 F6 129 case, we'll reset that to trial on 8/17. We'll leave the negotiations open. What was our record date on the 8/17 trial?
Okay. News today as well, Your Honor.
Both of them were set for today? All right. Parties' thoughts on a continued record?
I think a further record would be beneficial, Your Honor.
Because you need to check with witnesses on dates, right?
Want to go all the way to, when we go to the very end of July, which only gives us another 3.5 weeks, but we could go to the 29th.
I think any day between the 20th to the 30th, Your Honor, is fine, let's say.
Mr. Kozlich, does
This is
7/29 work for you?
That works, Your Honor.
All right, so we'll set everything for record on 7/29. That is your new deadline for a plea, to give you that opportunity to explore those options. And we have both matters now set for trial on 8/17, which was already the trial date for 127. Okay, sir?
So you said the first case and this case, August.
Yes, sir. Yep.
And we're gonna come back in a couple weeks for record date again, okay?
Okay,
Thank you, Mr. McDonald.
Thank you, Mr. Briggs.
so you, oh,
Yeah, I'm gonna talk with the state a little bit more about what you and I had chatted about and see if we can shake something loose, but I'm not super hopeful, but I'll come by and talk to you about it either way.
okay, I wish you would.
All right.
Thank you, Mr. McDonald. You too, sir.
Next, I have Carlos Smith. Yeah.
Good morning, Mr. Smith.
So I know, Mr. Paul.
Just doing a job here. 2606 F6 578. Mr. Kozlowski's here in court working on your behalf, sir. We're here for this initial hearing. Your thoughts, Mr. Kozlowski?
We want to get this on the trial calendar on this initial appearance on my part. I do have discovery that was sent over about a week and a half ago. Still waiting on a plea, but I believe one will be coming. Once I get a hold of that, then I'll be able to talk to my client, but we want to get on the trial calendar now.
Want to use that 9/17 date?
That works, Your Honor.
Speak on my behalf.
You probably should hold off for just a minute here. Let us get you a couple of dates, then we'll see whether it's still necessary or wise. Okay, sir? We'll set your trial for 9/17. If you don't appear for that trial, it can be held in your absence. Looking at setting a record date mid-August. Your thoughts, Mr. Kozlich? Can you go week perhaps of the 17th? Come back on the 19th?
That works, Your Honor.
So 8/19 will be your record date. That's the deadline for entering into a plea agreement or filing any motions pertaining to your trial of 9/17. Mr. Kozlowski, are you prepared to take up any other additional matters?
Your Honor, I can't on bond. I'm happy to take that up.
Is that what you wanted to talk about, sir, your bond?
Yeah, if you can lower my bond too, that'd be good. Can I get a fast speed trial?
Well, it's.
That's something your attorney's got to do, and we're already set within that timeframe, I think, aren't we?
We are, Your Honor.
I got the rights to that.
Yeah, but we already set it within 70 days. So you've already got a trial date set within 70 days.
I know, I just want a fast speed trial. I don't know, smoke my innocence.
But,
I don't hit.
Your Honor,
It just gives you priority.
yeah, may I explain to him, Your Honor, just briefly?
Sure.
All that gets you is a trial within a certain time frame, and we have the trial within that time frame. Like you've achieved at the end.
Okay, well, that's not good, but, yeah, we got your trial date set, and we'll notice that it's a speedy trial, that way you have priority on that date. Okay? So we're good on that.
8/19.
9/17 is your trial, 8/19 is your record date, that's the deadline for entering into a plea.
All right, when you gonna come see me?
I'll be by, like I said, I'll be by to see you once I get everything together from the state, which shouldn't be much longer. They've already, like I said, they've already gotten 2 things over to me, so I don't think it'll be very long now.
Are we gonna take up the old Allen?
And Your Honor, I would ask to address this bond today.
Okay. Go ahead, sir.
Thank you, Your Honor. My client has 3 misdemeanor convictions and 1 felony conviction in the last 10 years, and he doesn't have any FTAs from that time frame. Based on his pretrial services report is CR 26. His bond is currently set at $4,000 cash, which is a bit on the high end for these F6 domestic battery charges. I would ask at minimum that we go down to $1,000, but I think that his given his history, I think $750 would be an appropriate amount to set bond at.
State any response there, sir?
You give me 1 moment, Your Honor.
I need to get in trouble. My last felony,
Your Honor,
2019.
the state is objecting, just looking for his criminal history, his prior convictions for batteries of D felony, batteries of D misdemeanor, resisting law enforcement, criminal recklessness. His history is just a big concern, Your Honor, as the fact that this is an allegation of a crime of violence, given that we do believe that $4,000 is an appropriate bond.
It's not too far out of whack, for sure. Or these type of cases and the concerns noted, the court's not going to adjust the bond for denying the motion today based on the information presented. Bond reduction denied today, sir.
If I may, Your Honor.
Go ahead.
I just want to make sure that, so Mr. Kozlowski, you are making a motion for fast and speedy for this?
Sure. Yes, sure.
I just want to make sure that that's adequately marked on the docket, Your Honor. Thank you.
Yep, it's noted.
And that B misdemeanor happened in Marion County. I was 25.
Okay,
32.
Sir, that we're not gonna change it today. We understand. Thank you. We'll see you on 8/19, if not before. If you do come to terms with the state of Indiana before 8/19, your attorney can get you into court sooner, okay? You're okay. You're okay. Where's that?
next year I have Pedro Soto. initial appearance.
Mr. Soto's cause number is 2606F6, 585. Good morning, sir.
How you doing, Mr. Font?
Good, thank you. So your attorney, Mr. Kozlowski's here in court, set for your initial today. Mr. Kozlowski,
We're asking for trial dates at this point, Your Honor.
on the chance that,
Or actually, I'm sorry, I was looking at the wrong case. Could I get a status date on this? The state got a plea offer over to me a couple weeks ago and discovery already, so I'm ready to advise my client on how he wants to handle this. So in the interest of keeping the trial court open, the trial calendar open a little bit, I want to have a chance to talk with my client about the offer, and he can make a decision up or down on that, now, since I have discovery and the plea, before we set that trial date.
okay, do you think, let's see,
2 weeks should be sufficient.
a week and a half, the 22nd, do you think that would work?
That would be perfect, Your Honor.
Okay. We'll set your case to 7/22, Mr. Soto. Your attorney's got the discovery materials. He's got a plea offer. He wants to go over that material with you. Okay? We'll see where we're headed on 7/22. If you need a trial date, we'll get you one on that date. If you've got an agreement worked out with the state, we can take care of that too. Either way. All right, we'll see you on 7/22.
A quick question, on my bail. They have two $1,500 bills on the same case. People here to pay my bill, but they said if they pay that $1,500, I still have another $1,500 on the same case. I don't know how that paid out.
That'll be it. Looks like it's set at 1,500 though.
Show that.
It's $1,500 cash to over 15,000 surety. Is what it's set at. Yeah, there's no. Can't see where anybody would get something different. On this particular case, unless there's another case involved, it's 1,500.
There's no other case on the booking, right here on the booking, when my girl came, pay my bill, they told her that I have two $1,500 bonds on the same case, same case number. I've never seen that happen before.
Yeah, that's not correct.
Yeah. And you know, there is also, and this, I don't know if this is exactly the issue because we're playing kind of a game of telephone here. So I don't know what happened at the jail, but I would note that in the pretrial services report, probation noted that my client has a very similar name and pulls up cases for someone else, a David Soto, because my client goes by David occasionally. And he has a warrant out of
For the other David?
yes.
David guy?
And so it's a $750 one. So that I'm not sure that would be what's raising the false flag, but it did raise a false flag for pretrial services.
Got it.
So I don't know if that's the problem, but I would point it out.
So we'll clarify just that pursuant to the order issued on June 16th of 26, the defendant's preliminary hearing bond was set at $1,500 cash, 15,000 surety. Defendant was ordered to participate on pretrial services and report for probation within 24 hours of being released from custody. So those conditions are going to remain in place, but we'll clarify that it is a 1,500 over 15,000 bond. Okay, so hopefully the court order will clear that up for you, and your lady can post that for you. Okay.
Hey, Your Honor.
On the other note about David Soto, I had the same problem last time I was here. If you look up the picture mug from where you got arrested, it's two different people.
Yeah, that's what it said on the pretrial services report. It says he doesn't look like you, so that's good.
Given that my client is indicating that there's a good chance he will bond out, could you have have him read out his phone number on the record, please?
You got an phone number where your attorney can reach you?
No, they broke my phone. They broke my phone. Actually, my phone didn't even come to with my property. I don't know where it came.
Can you give me like your partner's name or anyone that I can contact that I can get a hold of you? Who you'll be staying with, for instance?
I can give you that when you come back. I can't remember off the top of my head.
Okay.
Or when you come to see me or something.
Okay.
All right.
I'll get your information and get you that number right away.
Yeah, perfect.
As soon as if you bond out, it's the first thing you need to do, aside from after you check in with probation, the next thing you need to do is call your lawyer, okay?
And I think they just handed him a public defender sheet. So yeah, if you don't bond out, I'll probably be over by the end of the week, all right?
All right, thank you.
All right, thanks, man.
So when was the court date again?
7/22.
All right, thank you.
Yes, sir.
And then last year, or not, last, excuse me, next I have Richard, Kapitschka.
Good morning, sir.
Morning, Your Honor.
We're set on Mr. Kapishka's cause, which is 2401 F687. This PTR matter. We're set for sentencing on that matter. Are we ready to proceed with sentencing, Mr. Kozlowski?
I believe we are, Your Honor.
And then what we'll do, sir, is we'll hear from your attorney. He'll make his argument and recommendation, and we'll hear from the state. You'll have an opportunity to address the court if you'd like to. Okay? Yes, sir. All right. So, Mr. Kozlowski, the floor is yours, sir.
Thank you, Army. Approach to begin with.
Sure.
I have a very short letter here confirming his completion of MRT. That was back in 2025 last year. But it has a bit of good information there that I think it could be beneficial to the court. I'll stop for a second while you read it.
Yes. I have read the letter and looked at the certificate, Mr. Kapishka. See if you have an opportunity to see these things?
Yes, sir.
Good. Very good. Good work, Mr. Kapishka. Thank you. All right, then proceeding from there.
Thank you, Your Honor. As Your Honor can see from the violation factual that we did previously, you know, the allegation was that my client had not completed with kind of some follow-up treatments that was here. Treatment was not completed because he was having trouble balancing his work schedule and the treatment schedule. Since being discharged from that treatment, he has continued to go to, it's not aftercare, it's the group, right?
Yes.
He is continuing to go to group with Oaklawn and actually secured those documents and had a conversation with Ms. Emerson, his recovery coach, who's been active involved with him throughout this process. As the treatment coordinator noted, or the case manager noted, my client had maintained his sobriety throughout this. There's no allegation that he had tested positive in kind of a later phase here. This is just a problem where, you know, he was running the race, but ran a little outside of his life by not being able to complete that treatment. And, you know, to track, that means a disqualification. So, you know, I think that kind of spirit needs to be honored here. And what we're asking for is just unsatisfactory discharge in this case. The goal of these cases at the end of the day is to show behavioral changes and to try and to establish sobriety for people that are struggling. I believe my client has done that. He's out working right now. He's been working diligently for some time. He is supporting a family on his own while doing it. He understands that he is taking a hit on this and that if he ever gets in trouble again, that this will be a black mark on his record here. But I think that from Mr. Kapishka's standpoint, this is more about taking a bet on himself. You know, he's been doing well. He is ready in his view to take the training wheels off, so to speak, and try to fly on his own. You know, there's always risk to that. These services, I think if people make use of them, I think they can be helpful. I think that we've had a lot of people that have come through here that have benefited from that type.
So you save puppies every day? That's crazy. That's so cool. You need to go save a kitten today, Crystal. They ate chocolate, and you need to save them. Or they ate gummies, which is worse. And then you can laugh at them. Monica, thank you so much for your 1 whole year subscribed with Prime on Twitch. I appreciate it. Guys, if you have on Twitch and use your Prime membership and you can watch the stream.
Supervision. However, I think my client is in a position where the burden is too much for him to balance all of the other things that go along with kind of getting his life back in order. I think he has this substance abuse issue well enough in control. He has the tools that he needs in hand. He has a recovery coach that he's working with. He is going to group. He has completed MRT, which I think is one of the more effective forms of treatment that Oakland gives. I do like the MRT program, and when people actually engage with it, I think it is a really good way to change how people approach those problem moments and learn to make the right decision. And I think my client has done that here. I don't think that the community or my client would benefit him from being under further supervision here. Thank you.
Thank you, Mr. Kozlowski. State?
I leave it to the court's discretion, Your Honor.
Mr. Kapish, anything you want to say, sir?
Yes, through these programs, it helped me realize a lot of steps I need to take in my life. I recently just had one of my kids granted custody, full custody to me. I have another child that relies on me, and through this program that I did, and Miss Emerson, I was able to further my employment at Avenues Recovery Center as a new maintenance man. So I will be stepping up in another job stair. So
You have a new baby, don't you?
yeah,
You have a new baby. You just signed over the rest of the next 18 years of your life. You're not the boss of you anymore, right?
I haven't been for a while. I have 4 children altogether.
So, your wants and needs definitely take the back seat to
Yes,
those, the people that rely on you, including a new baby.
Yes, sir.
And so that's 18 years where you have to make decisions in their best interest before you even consider yours.
Correct.
And that means you have to be working, you have to be present, you have to be available. And none of that's compatible with substance abuse.
No, it is not.
So, here's the deal. If you come back because you're not a great candidate for probation anymore because you've been unsatisfactorily discharged, that really knocks out a lot of the court's options.
Yes, I
I
understand
mean,
that.
we understand that you're rolling double or nothing basically here, right?
My last chance, and I'm willing to take that. I have a great head on my shoulders. I have a great support group, and my children need me more than my own personal interest.
Don't. That is correct. In the moment, when the addiction becomes calling, remember that. That's
Yes, sir.
it's that moment where it matters. All right.
I've been doing 2 years, and I think I got a great handle on it.
Okay. Unsatisfactorily discharged from probation, can't come back. Got to only go forward.
Yes, sir.
Cortez burned the ships. You're on the same thing to deal with him. Okay.
Yes, sir.
All right. Good luck.
Thank you. Thank you.
Last, Your Honor, I wanted to recall a case Sherrard Cozy.
Yeah. Okay.
This is for Ms. Gudinski's case.
Okay.
How you doing, Joe?
I'm good, Mr. Cozy. I'm glad you're here. We had to put a warrant out for your arrest because you didn't show up. But now you're here, so withdraw the warrant. What are your thoughts on Mr. Cozy's case standing in with your partner, Ms. Skidinsky, sir?
Your Honor, I couldn't catch Ms. Gudinski before she left out from her 9 o'clock court. So I'm just asking that this be put on the next kind of available date that the court has, that she is also here. I think she's going to be here next week on either Monday or Tuesday. On Wednesday as well, I know. So.
Thursday's trial is going out.
This Thursday's?
Yes.
All right, Mr. Cozy, can you make it back for court on Thursday so you can have your actual appointed lawyer with you?
Yes, sir.
All right, we'll see you at 8 o'clock on Thursday.
Okay, thank you.
Thank you, sir. I'm glad you showed.
7-9, Your Honor.
Pardon me?
7-9.
Oh, yes, sir.
There you go. All right. Everybody also.
We'll see you Thursday.
Thank you. Take care.
Okay.
Thank you, Mr. Cole.
Yes, sir.
And I think that does it for me.
Thanks for filling in for your colleague. That's other people tell you that. Fourth in the batting order today.
That's all right,
Mr. Norris, batting cleanup.
All right. Hi, Mr. Bailey.
Mr. Bailey, clause number 2309 F6 993. Good morning, Mr. Bailey.
Good morning, Ron.
Mr. Norris, this is a status of council hearing, so you're in on Mr. Bailey's case.
Yes,
Your
Joe.
thoughts in moving forward, sir?
We're prepared to make an admission today.
When we first started talking about the PTR, Mr. Bailey, we told you you had a right to have a lawyer. You got Mr. Norris. We told you you had a right to have a hearing in which you could contest the allegations, and the state would have to prove those allegations to the court by a preponderance of the evidence. Remember that?
Yes, sir.
If you elect to make an admission today, you'd be waiving that right to hearing. Do you understand that?
Yes, sir.
Is that what you want to do today, sir?
Yes, sir.
The best of your ability, raise your right hand. You promise to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Mr. Norris, factual, please, sir.
Yes, Mr. Bailey, I know the judge looked a lot different back then, but were you placed on probation in this court?
Yes, sir.
Okay. And as a part of those probation rules and terms, you were to commit no new offenses. Is that accurate?
Yes, no worries.
And you did in fact commit a new offense in Elkhart County. Is that accurate?
Unfortunately, yes, I did.
Okay. And that's something that you had pled guilty to and you've served that sentence at this point. Is that accurate?
Yes, I did.
Okay. And also prior to that case, you also had a positive urine screen for drugs. Is that accurate?
Yes, I did.
Okay. I believe that's a sufficient factual basis, Your Honor.
Is the state satisfied?
Yes, Your Honor.
Based on your admissions and our talk about your rights, and the fact that you freely, knowingly, intelligently, voluntarily waived your right to hearing and made an admission that provides a factual basis for the violations. So that puts us in this position now to be ready to move towards a sentencing. What are your thoughts on that, Mr. Norris?
Your Honor, I'd love to move on to sentencing today if the court would hear that. You know, I don't know how the state feels about that, but I'd like to do sentencing today. Probation, were it to have ran its entirety, would have ended June 26th of 26. So I'd just like to have Mr. Bailey's case heard as soon as possible.
State, any thoughts? Do you need any additional information to make a cogent sentencing argument today, sir?
Well, first and foremost, my concern is having accurate credit time for him. Give me 5 minutes and we'll be able to go.
Okay. Just give the state a moment here.
I can listen to Mr. Norris as I room.
I think to help the state out, I think he's been here since June 12th. The argument that I'd like to make, Your Honor, is pretty simple for Mr. Bailey. I know that we've got that new offense, and one of the things and one of the reasons that we didn't enter an admission to the failure to get the classes done is because I think that was because of Mr. Bailey's incarceration. He's basically been in Elkhart for 6 months. He's been transferred back here. He was not released from there. What I would ask, Your Honor, is Mr. Bailey is at this point, he's got a partner who is going to be undergoing some very serious surgery. She's going to have a permanent colostomy bag as a part of it. And he knows that he needs to step up and be a caretaker in that situation. A lot of times this close to the end of probation, I would ask the court to consider, a time served and release from probation. However, in this given case, I don't want it to seem like Mr. Bailey is getting a benefit for receiving that conviction the last 6 months of his sentence. And I do think that there's some good that probation can still do here. He was willing and able to take those classes. I think that there was the one positive drug screen, and then there's the conviction right after. And I know that is ringing a bell in Mr. Bailey's head. There's never a conviction without drug use in his life, and that has been a theme, and that has been something that he's been trying to wrangle his whole life. And I would still like to see him have the benefit of probation, have whatever time told that he's been since the violation was filed, just to give him a head start. I know he's clean and I know he's sober. He's been incarcerated for between 6 and 7 months now. I just like to give him some tools to help address his addictions while he's able to focus on being a caretaker as well.
Thank you, Mr. Norris. State, have you got your thoughts together, sir?
Yes, Your Honor. First and foremost, it looks like he has 25 fresh days credits. They allotted him 134 actual days at time of sentencing toward a total 30-month sentence. He had an initial 18-month executed sentence followed by 12 months spent to probation. Your Honor, this was originally a domestic case. He pled guilty in Elkhart County to a felony domestic case. I think the gentleman had a shot, and evidently it did not go as planned. I believe executing the balance of that sentence would be appropriate given the nature of the violation.
Mr. Bailey, anything you want to say, sir?
Sir, I want to show this court in St. Joe County that I can complete my probation at least once on this record. I want to show, and I was halfway through it. I was committed into my classes. I was taking my IOPs, and yes, you're right. I slipped up and I had a failure on drugs. I was taking my classes. I was going to my meetings. Like I said, that's the only reason why I wasn't making my class. I want to continue and do what I need to do, and just get the avenues that I need done. Like my wife is going through a surgery here this Monday, and it's pretty serious. I'd like to be there for her if I could, and first and foremost, I just want to show that I can complete this, I'm just because I had to slip up, and what happened out there in Elkhart, I did the time on it, I got it done,
Thank you for the cheers, Monica. I appreciate it. Thank you.
on me, and I'm here now. I want to put this in front of me and get it done if I could, sir.
I hear what you want.
I can complete this probation, sir.
You might. I'm looking at a guy who took on the role of being provider and a protector for somebody. And you have abdicated that role at least twice. Turned around to be an agent of harm on the person you've sworn and agreed to protect. That is an abject failure in your role as a husband and a man. And for her condition now to be your basis for asking for some mercy here,
May I say something, sir?
I don't think you should. I don't think you should at all. Is that it's causing me dissonance in my brain.
Might I say one thing, Judge?
Mr. Norris, go ahead, sir.
Judge, this is for your benefit and the state's benefit. The factual basis and the probable cause affidavit in this particular case that we're talking of was a struggle. We really dove deep and thought about a self-defense argument, but this was a unique relationship because it was polyamorous and there was two alleged victims here, and I think that there was hitting back and forth, but I told James at the time, self-defense is going to be incredibly difficult when there's only three people in the room and two of them are saying that you're the problem. So I just wanted the court to be aware of that. I don't know if it'll make any difference in your decision, but I just wanted the court to have a little bit of a factual sense of what occurred in this case.
Okay, thank you, Mr. Norris. State, do you have anything to add based on that?
if that's the case, Your Honor, it's an additional partner to care for to break that promise and to harm. Additionally, he does also have another conviction for domestic battery out of Elkhart County back in 2010.
Balance in your sentence being opposed. You painted me into a corner. I can't believe it can last some fail. I'm sorry. I wish it were otherwise. And I feel bad for spouse, but at this point, the balance in your sentence opposed. You'll have, you say counted 25 days, I counted 31. Huh? See if we can. We'll order a credit time report because it's not of the essence of this moment, but we'll make sure that you do get credit for all the time that you served, Mr. Bailey. Hopefully your takeaway, sir, is that you just cannot anymore, okay? Mr. Norris makes a compelling argument, which is why I hesitated at all. Otherwise, it was just going to be, he made it harder for me, I guess, is what I'm saying, but I wish you the best, but you got to know that there's a line and these acts cross it and there's a price to be paid, sir. Sorry. Thank you.
Your Honor,
Ma'am.
just as a reminder, no contact order is still in place. I'm
Okay.
not sure
If that's something to be addressed by the parties in a later date, then we'll do it, but
I don't, just as a reminder, just the no contact or, and the, so there was already an initial 18 months, sir, so this is the 12 months that's being imposed, is that
right, and he's got some credit time towards that, whether it be 25 or 31 or something, but we'll get that credit time report and then we'll add that in later.
So it'll be a final. So
Okay, so
thank you, Judge. Thanks, Dave.
thank you, Mr. Newes.
Is that a Shiner, Judge? Did you have an argument with counsel?
Yeah, I wish. The story is actually so lame, it's not even good. I just smacked my face on the boat.
At least you're on a boat.
Yeah, there's that. And did it myself. All right, we do have Mr. Mikey left. Cause number 2606 F6 581. Good morning, sir.
Good morning, Your Honor.
Go ahead, MC right there, sir.
Have a seat right here.
Yes, sir.
Thank you.
You're set for an initial today. If you don't have an attorney with you, what are your thoughts on your attorney, sir?
Yeah, I'm seeking a continuance so I can hire a private attorney. I'm paid bi-weekly and I missed some work from being in jail over the weekend. I'm a bar manager, so the weekends are prime time for us.
Sure.
So if I could have a little bit more time, and then I will have private counsel.
Okay. When you say a little bit more time, that means different things to different people. What do you ask?
Well, again, we get paid bi-weekly. I mean, if I could get 2 to 4 weeks, that would be incredible.
Right. State your position on that.
I'm fine with whatever time from the court, just don't pull it, Your Honor.
Okay. Now, Mr. Mikey, how about are Mondays okay?
Yeah.
Monday, let's look real quick, let me make sure I'm setting in the hole of that date. Monday, August 10th, how about that?
That sounds
Go
great.
ahead and write it down on a slip of paper there, hand it to your attorney when you hire them.
Can I get the date one more time, Your Honor?
8:10, sir,
8:10,
at 8 a.m.
8 a.m. Thank you.
All right, we'll see you then, sir. Yeah, a gentleman sitting in the back here, and I think I'm out of names.
Mr. Robert?
Or is this Mr. Ford?
Mr. Robert.
Jeffrey Roberts.
Oh, okay, come on up, sir. Didn't hear that.
Oh, we were second.
Yep, we did. Okay. No. You had bus issues, right?
Yes, sir.
Okay.
I had plenty of bus issues.
Okay, so Mr. Blatt was here,
Yes, sir.
but he had another appointment, he had to go make in another court. And he told us about your bus issues and said, please, Judge, don't issue a warrant because he's not here. And I said, okay. And we reset your case to 7/29, okay, sir?
Yes, sir. I
All
appreciate
right,
it.
so your attorney, you can get back to get together on the same page and be ready to move your case forward then, okay?
Yes, sir. I will have reliable transportation next time.
Okay, you need to write that down before you leave, sir.
Write that
Oh,
down.
goodness, yeah. Did you say 27th or 29th?
7/29
Thanks,
at
sir.
8 AM.
Thank you very much, sir.
All right.
I apologize for making you wait.
You know what, it's okay, we were here anyway, sir. I mean, if nothing, if anything else, you just wasted the bus trip, but
Well, I didn't mean to waste my attorney's time either. I just.
no, we appreciate that.
No problem.
But sometimes life conspires against us and we'll just do the best we can, right?
As much as possible.
All right, Mr. Roberts, we'll see you then.
You have a good day, Bill. Thanks.
State, I think that's everything.
Please, so, Your Honor.
All right.
Okay, we are going to move on to Judge Sanford, which again we haven't seen in a while. I think I did a lot of Colorado lately, so we've been missing our Indiana judges.
Okay, so, guess I made a note to myself. I guess my question would be directed to the state. Why would I?
If I had one judge from Indiana that I could play all of his trials, it's this judge right here. He gets the craziest trials.
Or should I let this play?
I can't, unfortunately, you guys don't see all the trials because I miss like the verdict or it'll be an excellent trial, but I don't have the verdict or I don't have this or I don't have that, so I can't play it. I can't just play like part of a trial normally or the verdict I definitely need. But he's had some doozies.
Hey, I know you probably didn't negotiate, but you're on hot seat.
I did not judge.
You're the state. I know why the defendant would take the plea agreement, but
I mean, aside from what counsel could articulate, I'm not aware of any particulars on why this was made.
well, so when she was out on bond, 25/12/11/68, for a felony case, possession of meth. So she was out on bond and a felony, I guess. All right. So ma'am, I'm guessing, it wouldn't be very hard to guess, that you steal to support a habit. And even when you're out on bond and you're supposed to keep your nose clean, you're incapable of doing so. I know it's only an allegation or an outburst, but you still use them, would be my guess, and you will use you back then. I know why your lawyer would, I know why you and your lawyer would accept that plea agreement. And it's a binding, is it not? It's a binding.
It's a binding.
Let me go through your history, ma'am. You have a 97, you have a criminal mischief, driving while suspended, criminal conversion, driving while suspended, criminal conversion, driving while suspended, criminal conversion, leaving the scene, driving while suspended, criminal conversion, driving while suspended 1, 2, 3, 4, 5, 6 times in a row. That is a misdemeanor. Let's see.
didn't show up for your sentencing until 2022. Driving while suspended, false ID, batteries of felony, you were revoked
Thank you so much, Kit Kat. I appreciate it. Thank you.
on probation, theft, and conversions. So why would I think that you're going to do what you're supposed to do, man? Even when you're out on bond and you have this hanging over your head, that you were going to abide by this binding agreement that the parties want me to follow through on. I guess I'll leave that up to your lawyer to answer, or you I'll just defer to who you want to answer that question. You, Ms. Beachcroft, you're your client.
I would go ahead, given that Ms. Cressy and I negotiated this plea agreement together, I think the intent was originally for her to enter into drug court here in St. Joseph County. So we had taken leave for her to be able to do that, and then ultimately they rejected her after accepting her on the first case. She's an outstanding case in Elkhart where the anticipation is she's going to be accepted into drug court, and because they're so much more intensive, the plan would be to give her a 24-month sentence here, about 18 months over there. She'd have the 24 months hanging over her head here in addition to whatever she had in Elkhart. So I think initially our thought, the first time around with this, is that Ms. Jones would be in drug court with us, which would be something different because she hasn't done that before. When that no longer became a possibility for whatever reasons, Elkhart is still hanging out there. And Ms. Crespi and I spoke, and we believe that Ms. Jones, given her history, it's clear that she's an addict. She needs that underlying type of health combined with her victim status, that we thought she would be a good candidate, and that would be the hope. The 24 months hanging over her head here as a term of the agreement, that she must be compliant with that, and she wants it, she's asked for it, and that seems to be a difference that may make a difference this time. First time she's asked for it.
Well, yeah. He's 48 years old, man. 48. I don't see it changing, to be honest with you. I mean, I don't mean to sound so harsh, but I just don't see. So you want me to accept the police state or this house, you know? But yeah, you can address me when you get back. I'll get back to you in a minute. Yes. All right. Hey, you want me to accept it?
That's a convenient excuse, Kelly. I think the cats actually punched her in the face. I think so. I think she's in an abusive relationship with her cats, and she's blaming allergies. I think we should send help.
To HR. All right, Ms. Jones, back to you, ma'am. Why should I accept this plea?
I've never asked for help before, but I really do want it. I'm tired of the life that I've been living. I want to be there for my grandkids. And my youngest daughter's 10, and she's been through a lot.
Your youngest daughter's 10?
Yes.
Got it.
And she's been through extremely a lot. And I'm trying to just get better for her and to be a great grandmother. I lost my father while I was in here. And I don't want my grandkids to lose me. Or my kids. And if I continue down that road, that's where it's going to lead to.
So back in 2018, when you were sent over to the Michiana Community Corrections, they didn't send you to treatment, or have you? Nothing, really?
No.
Well, I did sentence you back in 2017, ma'am, and I did order you to terminate your probation to complete an IRS assessment and based on results, which is maintenance treatment program. So that was offered to you back in 2017, 9 years ago.
I don't remember.
You probably don't. You've been doing
I was
good.
probably high.
39 years old, man. 39 back then.
Yeah. I was on helping sovereign.
You eventually went to the Department of Corrections, and I think, man, I even gave you a suspended sentence. Yeah, I did. And then back in 2022, again, I had the pleasure of having you in front of me, and you were sentenced to 18 months in the Department of Corrections. And think I recommended that recovery is all incarcerated. And I would consider, I don't know what happened there.
And ended up sitting in the county for that year.
Yeah. And I'm not gonna put up with any BS while you're on probation, okay? So the probation department gives you time to hang yourself. And I'm not betting that you're gonna make it, but all due respect to you, you feel as you're going to, you're 48 years old, you've chosen this lifestyle, it's the way you're gonna live. Doing things for other people isn't a strong enough incentive for you to stop using, with all due respect, you gotta wanna do it yourself. But all right, I'm going to accept your plea, but I have zero tolerance for any crap.
Thank you. Thank you for giving me the chance to prove.
Well, man, you've had plenty of chance,
Thank you.
okay? You come back when you complete the program, and then you could say thank you, because I have my serious doubts about your ability. You're not a young woman anymore.
We have a warrant of Dr. Which will be transported there. So we won't see her until she's released from them.
I take it, ma'am, you don't have a job, or you weren't working before you go to rest, is that right?
No, I wasn't working in general lists.
Okay, Liz, the sentence is consecutive, 20D04, 2602, F6173. Pursuant to your agreement, ma'am, your sentence in, this is for 298, will be 24 months suspended. You have 99 days Class A credit. The probationary period will be for 24 months. It is completed an IRS assessment based on results participate in the training program, education class, legislative service provided by probation referral to an outside agency. We can continue to be started Elkhart County Drug Court programs. You'll need to sign releases so the probation department can monitor your progress. Any questions about that, ma'am? You're not to use a controlled substance without a valid prescription, use any illegal substance, nor are you allowed to consume alcohol while you're on probation. You'll submit to random drug and alcohol testing and put in the order that if you test dirty, ma'am, or you don't show up for a drug test because you don't have a legitimate reason, or you tamper with your drug, with your urine when you're giving a test or giving a drop, just one time, I want the probation department to let me know about that. That'll tell me that we're just wasting our time here and you just need to sit it out in jail and continue on the lifestyle you've chosen for yourself so far in the last 48 years. You understand your first submitted drug screen or ordered by your probation officer, both submitted drug graph return analysis service been diluted or tampered with will be considered a violation of probation. You will report to the probation department time to manner instructed by the court or your probation officer. You work faithfully, diligently, seek employment and or pursue education and training that apply to you. You will remain in St. Joseph County, Indiana, or Elkhart County unless given permission to leave by the court or your probation officer. You notify your probation officer to change your address in St. Joseph County or Elkhart County. Within 3 working days, you must obtain prior written permission from your probation officer to move your residency outside St. Joseph County or Elkhart County, Indiana. You can send your probation officer raising a home place of employment elsewhere. You waive any and all rights to strategic research to your personal property anytime while you're on probation. You waive extradition, agree to return or be returned to St. Joseph County without the formality of an extradition hearing violation. Any law may be considered a violation of probation. But if you turn probation, may result in revocation of probation, imposition of protocols, suspended sentence. Probation may be revoked in some circumstances up to a year after the terms expire. Ma'am, you have a question about your probationary terms?
No.
Okay. By signing your name to these terms, you acknowledge you understand the terms of your probation, agree to abide by them, including compliance with rules of payment of force if determined by any agency to which you are referred and where only the court may modify the terms of my probation. I also understand the civil suit and a petition to revoke probation may be filed against the probation as by financial obligations started by the court. So there was only one count, 298, 1168 is being dismissed as part of the pursuant to the plea agreement. He posted $445 in net pays for Liz. Posted nothing in patient pleading, so in that, the bond in that case, and 1168 is 445, and broke up the court costs.
I told him to go make me some money. Go get me some money, Bill. V, thank you so much for the cheers. I appreciate it.
$200 ADC fee, no. But this court costs and PD fee, the remainder will go to fund. You're not gonna get any money back. $445, good luck.
Thank you.
I wouldn't be betting for you, to be honest with you. I hope you make it, you come back and tell me that you did it.
I will, thank you.
Yeah, good luck.
Good morning, Your Honor.
Benjamin, who you have?
Gerald McNary.
Joe. There.
Your Honor, we're asking that the court schedule a record be filed in this manner.
How long did you try this case at the level 4? A couple of days?
2 days. I think so, Your Honor.
You say, did you have any other?
Mr. Staples.
You know what I haven't done? I've never checked to see if Chargaloff got his own courtroom yet. So if he did, we're missing all of his court cases because I've never looked to see if they gave him his own courtroom yet. And I can't today because I won't be home. Next week or later this week, I'll see if I can get Chargaloff's courtroom. I guess a new judge, that should be interesting, right? He's probably going to be a little harder, maybe. I don't know.
September 14th.
That is open, Your Honor. We've accepted that.
You are a second setting that day.
Your Honor, may we have a record date on August 17th? We'll be back here at the time. I'm not sure.
Okay, so August 17th, the record. So, Mr. McNary, your record date is August 17 at 9 o'clock. The purpose of the record date is to let the court know that you're going to trial or issues come up that would prevent you going.
Yeah, Vinny did not make it back yet. He decided to go to Delaware instead. So now he's in Delaware, I guess, doing whatever he wants. And Eileen Chargloff was one of the, we first met him in Cristofino's courtroom, but we've seen him in a bunch of these Indiana courtrooms. He was a lawyer. He was a prosecutor, I think. No, he was the defense attorney. I can't remember if he was a defense attorney or a prosecutor. I can't remember. But he became a judge. Now he's a judge. And I have to get his courtroom so we can see him. He's bald. You might recognize him if you see him, because we've seen him a couple times.
The trial, you weren't to show up on your record date. Two things have happened. One is they confirmed the trial even though you weren't here. And two is they issued a warrant for your arrest. Do you have any questions about your record date, sir?
No.
Okay, that's 9 o'clock. The trial date is September 14th. That's the 10th. You're the second setting that day. And I don't know if they really tell other people, but cases have a way being worked out between your record and trial date. You should be ready to go to trial on the 14th. And if your case is up and you didn't show up, the state says, you know what, Judge, we're ready to go to trial. We have the trial without you. Do you understand that?
Yes.
And on top of that, if I hadn't already done so, you should want to be arrested. Any questions about your record and trial date, sir?
No.
Get reminded you.
Yes, Chris, yeah.
Stay in touch with Mr. Payne.
He is so loud, Michael. He's so loud when he's playing his video games. He did make it. He was the #1 tank on Team Puerto Rico.
Thank you, Your Honor.
And now he's semi-retired.
Your Honor, I also have Carlos James. I'm appearing on behalf of Nicholas Muir from our office.
Mr. J.
Your Honor, this case is on for status conference. I believe that Mr. Muir has this worked out, but has not yet executed the plea agreement. He's asked that I ask the court, and I do so. I ask the court to continue this to July 27th at 9.
I won't be here.
Oh,
We can date in August.
okay.
State, well,
But
I don't know if anything's been signed yet. That's
I don't believe it. I don't believe it has.
So the state would ask for a record at a trial.
that's what. Okay, they're gonna be worked out or no?
My understanding is that it will be.
Have you talked to your client about the agreement?
Yes. He says that he has. Perhaps we could come back August 17th and get this completed.
Well, what do you think, Mr. Bennett? Is she your case?
No, it's not in our,
You guys can be record trial.
Ms. McKinney.
Okay, well, I'll tell you what, let's set this for August, and then if you haven't resolved it now, then we'll set it for it. I'll set it for a record trial. All right, so we see you on the 17th of August.
Thanks.
Yeah,
Thank you, Your Honor.
thank you, sir.
Yes. No, sorry.
Mistake or,
The pre-trial diversion paperwork was filed, Your Honor.
okay. Hey, man, you want to stand and raise your right hand for me, please? You swear to tell the truth, the whole truth, and nothing but the truth, so help you.
Yes.
Okay, well, none of the paragraphs are initial. But I'm reading it. Okay,
Sorry.
all right, man. What's your full legal name?
My name is Tatiana Moshaton,
How old are you, ma'am?
28,
Where are you going to school?
12th grade.
Read and write English.
Yes,
You understand English?
yes.
Go to the last page and I see three things. Do not recognize that every lawyer that the deputy prosecuting attorney, Ms. Cressy, that third signature, ma'am, is that your signature?
Yes,
Did you read this agreement before you signed it?
yes.
Ma'am, I'm gonna ask you a series of questions, to make sure you understand what's happening, what you're doing, that you entered into this agreement freely and voluntarily during the course of this hearing. If you have any questions, please ask them to stop. I'm gonna give you a chance to talk to Mr. Mattingly. You're not a citizen of the United States. Your conviction of the charges filed against you may result in favorable immigration status, deportation, and whether to give time to seek legal advice about this issue if you wish. Have an issue, Mr. Mattingly.
There you go.
Ma'am, are you currently the care of a doctor, psychiatrist for condition or under the influence of prescription medication? Any other medication, drug or alcohol that would affect your ability to understand what you're doing today?
No,
All right, the pertinent part of the plea. It says that you're gonna admit to resisting to the allegation contained in count 1, resisting law enforcement, level 6 felony, the state will dismiss count 2. That you the parties agree to defer judgment for a period of 12 months, and you waive any claims of delay under criminal rule 4 if you successfully complete each term outlined in the felony pretrial diversion agreement, individualized plan of action. The state will dismiss with prejudice the plea agreement or the plea offense, and if you fail, then I have to enter judgment on that count 1. I have to treat it as a felony. Do you understand that, ma'am?
yes,
And I won't have any discretion there. I have to treat it as a felony. And then the party will be free to argue with as to what the appropriate sentence. Right? That your understanding as well?
yes,
Now, there was a mention of this individualized plan of action, and I'm looking at this, but so you mentioned, I'll go to the last page of that agreement. I see the signature from Anthony Ireland, you the prosecutor's representative. I see your lawyer's signature. That third signature, man, was that your signature?
yes,
Have you read this individualized plan of action?
yes.
Do you have any questions about it?
No,
You understand what your obligations are in both the plea agreement and the individualized plan of action?
yes,
And Mr. Mattingly, you feel confident going forward, your client understands what her obligations are?
Yes, sir.
All right. Now, hopefully, I won't have to address this issue, but if you don't follow through, man, there's no cap on what the sentence I can impose is. You understand? So I could give you an executed sentence in 30 months. And there's a paragraph in your plea agreement that you waive any argument you have regarding that sentence. You understand that?
yes.
Number 9, Your Honor.
Oh, okay, thank you, sir. You understand that you have a right to appeal your sentence if there's an open plea. An open plea is an agreement which leaves my sentence to the judge's discretion. I hereby waive my right to appeal my sentence under each of the state as long as the judge sentences me within the terms of my plea agreement. So ordinarily, ma'am, you'd have a right to appeal your sentence, but because of that paragraph, you're waiving your right to appeal your sentence, except if there's an issue outside the scope of the waiver, the sentence violates the term of your plea agreement, or the sentence is illegal because it falls outside the prescribed statutory range or is unconstitutional. You understand the consequences of your appeal waiver?
Yes,
Any questions about that, ma'am?
no,
Had you gone to trial on the charge of pleading guilty, the state would have had to prove beyond reasonable doubt using the legally admissible evidence on or about February 4th, 2026, in St. Joseph County, state of Indiana, the unit knowingly flee from Bo Ennis, a law enforcement officer, after the officer identified himself by visible or audible means to visibly or audibly ordered you to stop, and in committing the act, you used the vehicle. Since you're being guilty to that charge, man, the state won't have to prove the charges in trial, but instead the judgment of conviction be entered in sentence imposed because there's no trial, you don't follow trial rights. Speedy public trial for judge and jury to confront and cross-examine state's witnesses, call witnesses on your behalf to be able to testify. You understand you're giving up those rights?
yes,
You have questions about your rights?
no,
You're also giving up the right to appeal your conviction, and you're giving up the right to appeal your sentence as long as you follow the terms of your plea agreement. Do you understand that?
yes,
Sentencing range for a level 6 felon is you start out with an advisory sentence of a year, which we added a year and a half for aggravating circumstances. Usually that biggest aggravators are criminal rates. Although there's other aggravators as well. 6 months can be subtracted from mitigating circumstances. Usually the biggest mitigators a lot of the criminal history, other mitigators as well. And you can be fined up to $10,000. Now, normally, I'd be able to consider treating this as a Class A misdemeanor, which has a range of sentence from 0 days in jail, 365 days in jail, fine of $5,000. So if I accept this plea, I won't have that option. You understand?
yes,
All right. Were you out on probation, parole, bond, or without sentence on any other case when this offense occurred?
no,
Eligible for community correction theoretically, Mr. Matty?
Yes, Your Honor.
And if you are sentenced on a felony, you have to submit for DNA swab. Do you understand that?
yes,
Having gone through the rights of waiving the possible punishment you're facing, do you still want to plead guilty?
yes,
Has anyone forced or threatened you to plead?
no,
Have you made promises to the state, or has the state made promises to you, not contained in the plea agreement?
no,
Court's not bound by this agreement. If I accept it, I'll be bound by its terms, which means I can't refuse to reduce or suspend and impose a sentence unauthorized by agreement without the state's permission. If I reject the plea, be treated as if it never existed. Other than the terms of your plea agreement, ma'am, will you guarantee what your sentence would be?
no,
Are you happy with the lawyer, Mr. Manning?
yes,
Do you still want to plead guilty?
yes,
Factual basis, sir.
Ms. Eathorn, let's go back to February 4th, 2026. On that day, did you operate a motor vehicle here in St. Joseph County, state of Indiana?
yes,
And law enforcement officer, later identified as Officer Ennis, had pulled up behind your vehicle and activated his lights to the unmarked police vehicle. Is that correct?
yes,
And then is it true that he got out of the vehicle, approached you, and he did several things to get your attention? Is that right?
yes,
He raised his arm, he yelled out and said, "Hey," and then twice yelled out for you to stop the vehicle. Is that correct?
yes,
And rather than stopping, you indeed fled from Officer Ennis. Is that right?
yes.
No further questions, Your Honor.
Okay.
Nothing based on that.
It was just Guns N' Roses, Michael.
Man, when you plead guilty, give up any defenses you might have. Understand that?
Yes,
You're admitting to the crime of resisting law enforcement, a level 6 felony, because that's what you want to do.
yes,
Okay, court finds the defendant understands the rights, charges, about felony sin, and leave freely and voluntarily, provided facts and basis for it now. Unconditionally accept the defendant's plea. So, was this 12 months?
Yes, Your Honor.
see you on July. Yeah, July 7th, I guess. 2027. Or they'll just dismiss it. Okay, but that's the cutoff. If I see you before then things didn't work out very well. So, hey man, here's an opportunity to avoid having a conviction on your record. Don't blow up, please, okay? Follow through on everything you're supposed to do.
Yes.
Anything else?
Yes, she posted a $700 cash bond. She'd like that to be applied to program fees and any remaining bond, sent back to her so I can write down her address.
How much did you post, man?
$750.
So what's the,
How much did they file? Cause normally on these.
yeah, they usually file
They file something.
I have a proposed order on bond. I guess, calls for $315 programming fees and court costs of $164, so there would be some balance remaining.
You get that amount, please.
Can I have it one more time? 315.
Yeah, fees.
Yes, and $164 court costs.
Okay.
Remainder to, and it. If you want to put your address down there, the clerk will send you a check.
Nope, that's good.
So you're returning it, sorry.
All right, guys, we made it to the end of Indiana Day. Appreciate you coming out today. I really, really do. No stream tonight. I'm working. I'll see you tomorrow morning, guys. Behave, okay? Have a great day. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace, come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like myself.